You are arrested. Maybe it is a mistake. Maybe it is not. That is what the trial is supposed to sort out. But right now you are sitting in a room, and you cannot afford a lawyer. Not a retainer, not an hourly rate, not any of it. And here is the one thing you are sure of, because you have heard it your whole life, in every arrest scene, in every show you have ever watched. If you cannot afford an attorney, one will be provided for you. The state will give you a lawyer. That is a promise written into the Constitution, and it is real. It is one of the most important promises the Bill of Rights makes. Right then you meet the lawyer, and the lawyer has 150 other clients this month. The lawyer has had your file for a day, maybe an afternoon, maybe 20 minutes in the hallway before your hearing. The lawyer is competent, overworked, and gone the moment your case is called. You got your lawyer. What you did not get was a defense. So here is the question for this primer, and it is the gap at the center of the Sixth Amendment. Every defendant has the right to a lawyer, so why does that right so often fail to deliver an effective one? This is Do It for the Case Law, Doctrine Deep Dives Season 0, the amendments, one at a time, one sharpest gap each. Today, the sixth. Start with the text, because the sixth is a bundle, 7 guarantees packed into a single sentence, and one of them holds up all the rest. The Sixth Amendment is the Trial Rights Amendment. It is the one that says in the words of the text that in all criminal prosecutions the accused shall enjoy a whole bundle of protections, a speedy and public trial, an impartial jury, notice of the accusation, the right to confront the witnesses against him, compulsory process to bring his own witnesses in, and, last in the list but first in importance, the assistance of counsel for his defense. Speedy trial, public trial, jury, notice, confrontation, compulsory process, counsel. 7 guarantees, 1 amendment. We're going to take the last one, the right to counsel, and here is why. Counsel is the guarantee that makes the other 6 usable. You have a right to confront the witnesses, but who cross-examines them. You have a right to an impartial jury, but who picks it, who objects, who argues to it. A layperson standing alone in a courtroom has all of these rights on paper and no practical way to operate a single one of them. The lawyer is the operator. Take away counsel, and every other trial right becomes a button the defendant cannot reach. But to see how big a promise Gideon made, you have to know how narrow the promise was before it. Because the court did not go from nothing to Gideon in one step. It went there over 30 years, and it started with 9 teenagers who were nearly executed. In 1932, the court decided Powell versus Alabama. The defendants were the Scottsboro Boys, 9 young black men accused of raping 2 white women on a freight train in Alabama. They were tried in a matter of days, in a town under military guard, before all white juries, and 8 of them were sentenced to death. What they did not have, in any meaningful sense, was a lawyer. The trial judge had appointed in a gesture all the members of the bar to represent them, which in practice meant no particular lawyer was responsible for any particular defendant, and no one investigated anything. The Supreme Court reversed, and in doing so it said something about what a hearing actually is. Here is the language, verbatim. The right to be heard would be in many cases of little avail if it did not comprehend the right to be heard by counsel. Read that carefully, because it is the intellectual seed of everything that follows. The court is not saying counsel is a nice addition to a fair trial. It is saying the right to be heard, the most basic thing a trial is for, is close to worthless without a lawyer, because a defendant cannot operate the proceeding himself. That is the same insight Gideon would rest on 3 decades later. But Powell was narrow a capital case, in circumstances the court called uniquely dire. It did not announce a general right to appointed counsel. It announced that in this case, on these facts, the absence of counsel was a denial of due process. 10 years later, the court was asked to make that general, and it refused. The case is Betts versus Brady, decided in 1942, and it is the decision Gideon exists to destroy. Smith Betts was an unemployed farm worker in Maryland charged with robbery. He asked for a lawyer. The judge told him the county appointed counsel only in murder and rape cases. Betts defended himself and was convicted. The Supreme Court affirmed, and its reasoning is worth hearing in full because it is the road not taken. Here is the holding, verbatim. The 14th Amendment prohibits the conviction and incarceration of one whose trial is offensive to the common and fundamental ideas of fairness and right. And while want of counsel in a particular case may result in a conviction lacking in such fundamental fairness, we cannot say that the amendment embodies an inexorable command that no trial for any offense, or in any court, can be fairly conducted and justice accorded a defendant who is not represented by counsel. Listen to the structure of that. Not a rule, a case-by-case inquiry. The absence of a lawyer might make a particular trial unfair, and if it did, that trial could be reversed. But there is no across-the-board right. Every poor defendant had to prove after losing that his own trial had been unfair in some special way. For 21 years, that was the law of the United States. You got a lawyer if you could pay for one, or if a judge decided your case was unusual enough to warrant it. That is what Clarence Earl Gideon was up against when he wrote to the Supreme Court from a Florida prison cell, not a gap in the law, but a decision squarely against him. And in 1963, the court overruled Betts outright. For most of American history, that right did not mean what you probably think it means. The Constitution guaranteed the assistance of counsel, but for a long time that was read to guarantee only that the government would not stop you from hiring a lawyer, not that it would give you one if you were poor. That changed in 1963, in the case this episode is named for, Gideon versus Wainwright. Clarence Earl Gideon was charged with a felony in Florida, could not afford a lawyer, asked the court to appoint one, and was refused. He defended himself, lost, and from his prison cell hand-wrote a petition to the Supreme Court. The court ruled for him, and it made the right to appointed counsel a constitutional requirement in felony cases. Here is the holding, verbatim, in our adversary system of criminal justice. Any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. Read that carefully. It is not a small idea. The court is saying a fair trial is impossible without a lawyer, and so the state has to supply one. And here is the coda that proves the court right. Gideon was tried again, this time with an appointed lawyer at his side, and this time he was acquitted. Same facts, same courtroom, a different result. The only thing that changed was that he had a lawyer. That is the power of the right at its best, and it is exactly why the gap we are about to find matters as much as it does. 9 years later, in 1972, the court pushed the promise past felonies. In Argersinger v. Hamlin, it held that the right attaches whenever the defendant is actually going to be locked up, no matter how minor the charge is called. Here is that holding, verbatim. Absent a knowing and intelligent waiver, no person may be imprisoned for any offense, whether classified as petty misdemeanor or felony, unless he was represented by counsel at his trial. Put Gideon and Argersinger together, and the promise is enormous. If the state wants to put you in a cell, the state has to make sure you had a lawyer. Now watch what the word effective does to it. Because a right to a lawyer is not the same thing as a right to a good lawyer. Gideon puts a body at the table next to you. It does not by itself say anything about whether that body did its job, and so the whole question moves downstream. Suppose you had your appointed lawyer, and the lawyer was terrible. Missed the deadline, never investigated, never called the one witness who would have cleared you, slept through parts of the trial. It happens. You are convicted. Can you get that conviction thrown out because your lawyer failed you? For that, you need the Sixth Amendment to guarantee not just counsel, but effective counsel. And in 1984, the court told us exactly how much effective it guarantees. The case is Strickland v. Washington, and it is the most important case that almost nobody outside the law has ever heard of. Start with what Strickland concedes, because at the level of principle, the court is generous. It affirmed that the Sixth Amendment does not merely promise a lawyer in the room, it promises a working one. Here is the court's own framing, verbatim. The Sixth Amendment right to counsel is the right to the effective assistance of counsel, and the benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. Listen to how good that sounds. The right is to effective assistance. The question is whether the lawyer's failures broke the trial so badly that you cannot trust the result. If the doctrine stopped there, it would be a real guarantee of a real defense. But the court then built the machinery for answering that question, and the machinery is where the guarantee quietly thins out. Strickland held bid want you.
You have to get both parts to win.
Here is the holding, verbatim. A convicted defendant's claim that counsel's assistance was so defective as to require reversal of a conviction or death sentence has two components. First, the defendant must show that counsel's performance was deficient. Second, the defendant must show that the deficient performance prejudiced the defense. Two components, deficient performance and prejudice. Miss either one and you lose, and the conviction stands. Now look at how high the court set each bar. Take the first component, deficient performance. You might think this asks a simple question. Was the lawyer bad? It does not. The court instructed the reviewing courts to lean hard toward assuming the lawyer was fine. Here is the language verbatim. Judicial scrutiny of counsel's performance must be highly deferential, and the court did not leave that to implication. It spelled out the presumption, verbatim. A court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance, which means, the court said, that the defendant must overcome the presumption that, under the circumstances, the challenged action might be considered sound trial strategy. Overcome the presumption. The burden is on you to prove your own lawyer was not secretly being clever. Did not call a witness? Maybe that was strategy. Did not file the motion? Maybe that was strategy. The presumption runs in favor of the lawyer, not in favor of you. Ordinary bad lawyering routinely clears this bar because highly deferential review was built to let it clear. And it is worth reporting why the court set the bar that high. Because the court was candid about it. Here is the reasoning, verbatim. It is all too tempting for a defendant to second-guess counsel's assistance after conviction or adverse sentence, and it is all too easy for a court, examining counsel's defense after it has proved unsuccessful, to conclude that a particular act or omission of counsel was unreasonable. That is a real concern. If every lost case could be relitigated as a referendum on the lawyer, no conviction would ever be final. So the deference is not laziness, it is deliberate. But deliberate or not, the effect is the same. The standard is engineered to tolerate a great deal of bad lawyering, and it does.
Before we get to that gap, I owe you a citation because I just made the strongest factual claim in this episode and I have not shown you where it comes from. I said public defenders carry caseloads several times what any professional standard says is manageable. That is either documented or it is a slogan, and on this show it had better be documented. So here is the document. For 50 years, the working number in American indigent defense came from a 1973 report by the National Advisory Commission on Criminal Justice Standards and Goals. One lawyer, no more than 150 felonies a year, or 400 misdemeanors. That number ran the field, and it was not the product of a study. The Public Defender's own National Association now concedes in its own guidance that the old standards rested on educated guesses.
In September 2023, the guess was finally measured. The RAND Corporation, the National Center for State Courts, the American Bar Association Standing Committee on Legal Aid and Indigent Defendants, and the lawyer Stephen Hanlon published the National Public Defense Workload Study. The lead author is Nicholas Pace. They reviewed 17 earlier state-level studies and then convened a panel of 33 experienced criminal defense attorneys to estimate, case type by case type, how many hours competent representation actually takes. The answer was about twice what anyone had assumed. Applied conservatively, the study's hour figures support a maximum of roughly 59 low-level felonies per attorney per year, 59 against a standard of 150 that offices were already blowing past. And this is not a report sitting on a shelf. In June of 2025, the Washington Supreme Court rewrote its own rules on the strength of it, cutting the limit for that state's public defenders from 150 felony cases a year to 47, phasing in from 2026.
I also want to be straight with you that the number is contested. John Gross, who directs the Public Defender Project at the University of Wisconsin's Law School, has argued that the study's expert panel was primed and anchored to overestimate the hours and that the resulting limits are unrealistically low. He also agrees the old standard was arbitrary and should be abandoned. So the honest state of the evidence is this. The old number was a guess, the new number is disputed, and every figure in the argument is far below what a great many lawyers are actually carrying. Which raises the question this whole episode has been circling. If a lawyer is carrying 3 times what the best available evidence says is manageable, isn't that by itself a violation of your right to counsel? The Supreme Court has answered that. The answer is no. The case is United States versus Cronick, decided in 1984, the same year as Strickland. Cronick's appointed lawyer was given 25 days to prepare for trial, and the Court of Appeals thought the surrounding circumstances alone were enough to presume the defense had failed.
Start with what Cronick gives you because it is real. Verbatim, if counsel entirely fails to subject the prosecution's case to meaningful adversarial testing, then there has been a denial of Sixth Amendment rights that makes the adversary process itself presumptively unreliable, entirely fails, and then you do not have to prove prejudice because it is presumed. That is a door. Now watch how narrow it is. Verbatim, only when surrounding circumstances justify a presumption of ineffectiveness can a Sixth Amendment claim be sufficient without inquiry into counsel's actual performance at trial. And on the 25 days, the court took up the exact argument an overloaded defender's client would make. The government had floated a presumption where counsel is subject to external constraints. Here is the answer, verbatim. The fact that the accused can attribute a deficiency in his representation to a source external to trial counsel does not make it any more or less likely that he received the type of trial envisioned by the Sixth Amendment, nor does it justify reversal of his conviction absent an actual effect on the trial process or the likelihood of such an effect. Read that again with 59 and 150 in your head. A crushing caseload is the textbook example of an external constraint, and the court has said an external constraint, standing alone, is not enough. You are back at Strickland. Specific errors, provable prejudice, burden on you. Now, the gap. Now the second component, prejudice, and this is where it gets even harder. It is not enough to prove your lawyer blew it. You also have to prove it changed the outcome. Here is the standard, verbatim. The defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. And in weighing that, the court added, a reviewing court must consider the totality of the evidence before the judge or jury, which, when the case against you was strong, is exactly the evidence that makes it hardest to show a better lawyer would have flipped the verdict. So stack the 2 prongs on top of each other and see what a defendant actually has to carry. First, prove your lawyer's work was not just bad but constitutionally deficient and do it past a presumption stacked against you. And then, even having proved that, prove that a competent lawyer probably would have gotten you a different result. You can lose on the second prong even after winning the first. A court can say, yes, your lawyer was deficient, but the evidence against you was strong enough that better lawyering probably would not have mattered. Deficient counsel, and the conviction stands anyway. That is Strickland. And Strickland is not some dusty outlier. It is the gate that nearly every ineffective assistance claim in the country has to pass through in trial courts, on direct appeal, and habeas petitions filed years later, and the great majority of those claims do not make it past the 2 prongs. This is not a footnote. This is the working law of what your right to a lawyer is actually worth once the lawyer disappoints you. Now, everything we have said so far has been about trials. Strickland is a test about what a lawyer did at trial, and whether a better lawyer would have produced a different verdict. And there is something quietly absurd about that, because in the American criminal system, the trial has very nearly ceased to exist. The court has said so itself, in plain numbers. In 2012 in Lafleur v. Cooper, it wrote this, verbatim, criminal justice today is for the most part a system of pleas, not a system of trials. 97% of federal convictions and 94% of state convictions are the result of guilty pleas. Sit with those figures, 97 and 94. That is not a statistic about a corner of the system, that is the system. The jury trial, the thing the Sixth Amendment is organized around, the thing every guarantee in it is written for, happens in something like 3 to 6 cases out of 100. For everyone else, the entire criminal process is a negotiation, a charge, an offer, a deadline, a decision made in a hallway or a holding cell with a lawyer you may have met that morning. If the right to counsel means anything to the ordinary defendant, it has to mean something there, at the plea, and not only in a courtroom most people will never see. And for a long time it was genuinely unclear whether it did. If you pleaded guilty, you had waived your trial, so what exactly was there to be ineffective about? The court answered that in 2012 in a pair of cases decided the same day. The first is Missouri versus Fry. Fry's lawyer received a written plea offer from the prosecution and simply never told him about it. The offer expired. Fry later pleaded guilty on much worse terms. Here is the holding verbatim. Defense counsel has the duty to communicate formal offers from the prosecution to accept a plea on terms and conditions that may be favorable to the accused. So the Sixth Amendment does reach the plea stage. Your lawyer has to tell you the offer exists. LaFleur, the companion case, went a step further. A defendant who rejects a plea because of demonstrably bad legal advice and then receives a much harsher sentence after trial has a claim too, even though the trial itself was perfectly fair. The court rejected the argument that a clean trial cures everything that went wrong in the bargaining that preceded it. And 2 years before those, in 2010, the court decided Padilla versus Kentucky, which pushed the duty into what the plea will actually cost you. Jose Padilla was a lawful permanent resident of 40 years, a Vietnam veteran who pleaded guilty to a drug charge after his lawyer told him he did not have to worry about immigration consequences. That advice was wrong. The plea made his deportation virtually automatic. Here is the holding. Verbatim, counsel must inform her client whether his plea carries a risk of deportation. Taken together, Fry, LaFleur, and Padilla look like the doctrine finally arriving where the defendants actually are, and they are real wins. But notice what did not change when they landed Strickland. Every one of these claims still has to clear the same 2 prongs: deficient performance measured against a strong presumption that your lawyer was being strategic, and prejudice, meaning you must show a reasonable probability that the outcome would have been different. In the plea context, that second prong asks a defendant to reconstruct a bargain that never happened, to prove the prosecution would have kept the offer open, that he would have taken it, and that the judge would have accepted it. The right now formally reaches the 94%. The test it has to pass through was built for the 6, and now set that legal standard against the world it actually operates in. The right to appointed counsel created an enormous demand for lawyers, every poor defendant facing jail, in every court, all at once, and the funding to meet that demand has never remotely kept pace. Public defenders in many places carry caseloads several times what any professional standard says is manageable. Hundreds of open files at a time, minutes to spend on cases that will decide years of a person's life. Clients met for the first time on the day of the hearing, charges the lawyer barely had time to read. Deals worked out fast in a hallway. In large parts of the system, that is not the exception. It is the ordinary texture of the thing. That is not a court holding, it is the documented chronic reality of indigent defense in this country. And here is how the 2 pieces lock together. The Constitution guarantees the lawyer. Gideon and Argersinger see to that. But the doctrine that is supposed to guarantee the lawyer was any good, Strickland, is so deferential that the ordinary consequences of a crushing caseload, the rushed file, the lead never run down, the witness never found, almost never rise to the level that undoes a conviction. The system produces overwhelmed lawyers, and the standard is built to forgive exactly the kind of failures that being overwhelmed produces. Which brings us to the gap. Here is the thesis, and it is a sharp one. The Sixth Amendment right to counsel guarantees you a lawyer. It does not guarantee you a defense. Assistance of counsel is satisfied on paper by a warm body at the table with a bar card, someone the record can call your attorney. Gideon and Argersinger make sure that body is there whenever you are going to be locked up, but whether that body had the time to read your file, the funding to hire an investigator, or the hours to prepare a real defense, the doctrine, through Strickland, almost never asks. And on the rare occasion it does ask, it asks under a standard so deferential, and behind a prejudice requirement so demanding, that only the most extreme failures, not merely bad lawyering but catastrophic lawyering that clearly changed the outcome, will undo the conviction. And remember that the overwhelming majority of criminal cases never reach a jury at all. They end in plea bargains, negotiated quickly, often by exactly the overwhelmed lawyers we have been describing. A standard this hard to satisfy after a full trial is the backdrop against which all of that faster, quieter resolution happens, which means the gap is not some rare appellate curiosity. It sits underneath the ordinary machinery that disposes of nearly every criminal case in the country.
I notice what that does, because it is the same move we keep finding across the Bill of Rights. The promise is written for the person, the accused, standing alone, needing help. But the doctrine ends up tracking something more formal than that person's actual experience. Gideon asks one question: was there a lawyer? Strickland asks another: was the lawyer's failure extreme enough and provably decisive enough to disturb the judgment? Neither one asks the question the defendant actually lives. Did I get a real defense? Remember the benchmark Strickland announced, whether counsel's conduct so undermined the adversarial process that the trial cannot be relied on. That is a promise about the reliability of the trial. The two-pronged test that follows is a promise about how rarely a court will find that reliability broken. You can have a lawyer who never had a chance to defend you lose your trial and lose your appeal too, because on the court's definitions you got everything the right, as interpreted actually promises. The right guarantees the assistance of counsel. It does not guarantee that the counsel could assist.
That is the sample. A full Amendment 6 season on this show would take each of these guarantees in turn, the speedy trial clause and what speedy has come to mean, the jury right, the confrontation clause, and your right to face the witnesses against you, and the counsel right in its full depth, from Gideon through Strickland and everything the ineffectiveness doctrine has built on top of it since. One doctrinal question per episode, each anchored in cases we verify. Not remember. A quick word on how this show works. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, not telling you what to do if you are ever the person in that courtroom. And everything is built on real, named, verified cases. Gideon, Argersinger, and Strickland were all pulled from the court's own opinions before I wrote a word, and every citation is in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.